And this year we are extremely pleased to have with us former judge and Vice President of the European Court of Human Rights and Professor of Law from the University of Louvain in Belgium, Françoise Tulkens. She was a professor in Louvain for a number of years, teaching in the fields of criminal law, comparative law, juvenile justice, and human rights. She was appointed to the European Court of Human Rights in November 1998 and completed her term just last year in September 2012. She was a president of a section of the court from January 2007 and vice president of the court from February 2011. She's a member of the Belgian Royal Academy since 2011, currently chair of the Board of Governors of the King Baudin Foundation, and since September 2012 has been a member of the UNMIC Human Rights Advisory Panel. And for those of you who I think follow the jurisprudence of the court, Judge Tulkens' opinions are always interesting, always fascinating to read, and I have actually in particular great respect for your opinions in the various headscarf cases, which I think are not only extremely well argued, but I think by far preferable to those of the majority in those cases. So it's wonderful that she's agreed to be here to address us today. She will speak for an hour, and then there will be half an hour for questions. She will field her own questions. Thank you very much.
Thank you very much. Thank you, Marej. So, dear friends, so first of all, I'm quite happy because I read your resume and I saw that there are 5 or 6 among you who are at the European Court of Human Rights now. So I will be delighted to see them after the lecture. So, of course, I am very happy and I'm very honored to be here with you. And the European Convention of Human Rights is more than ever our common heritage. And that's for me very important because we share in this respect a common responsibility, national, international level, judge, scholar, and you are, more of you are scholar or PhD student. And that is why I really appreciate this kind of meeting, since it gives us the opportunity to discuss the right and freedom enshrined in the Convention as they are interpreted today in the context of our contemporary society. And that's for me the most important thing, because this is really the intelligence of the Convention. Through the court interpretation, the rights written in the Convention in 1950 can have a meaning today in the society of 2013. And as legal theorists have observed, the law, of course, must be stable, yet it cannot stand still. And that's for me the very important point in the interpretation of the court case law. Adaptation and modification have been constant features of the Convention since 1950 and continue to be so today. So in this lecture today about the European Convention and the economic crisis and the issue of poverty. In this lecture, I will examine the contribution of the European Court of Human Rights to the fight against poverty and social exclusion. And I argue, but of course that could be disputed by you, I argue in favor of a reading of the European Convention of Human Rights that is aligned with the necessities of the time, of our time. And in the face of global financial and economic crisis that develop, and we know that since 2008, this does not mean sacrificing human rights in the name of austerity and macroeconomic discipline. It means improving the protection of the most vulnerable people and marginalized segment of the population in a context in which the right to access to court, to housing, or to social security, and I will develop all this thematic, have gained relevance and importance. I will start in this lecture, no more than 1 hour, I promise you, otherwise I will cut immediately the micro. So I will start by saying a few words about crisis. Crisis and particularly economic crisis and human rights, before examining different aspects of the European Court of Human Rights case law addressing the question of poverty. Since I do not have today something to use for a PowerPoint, I gave you a plan, so you can follow easily. Sorry, because I didn't have the material for a personal reason. So, first of all, a few words about crisis and human rights. Clearly, economy and human rights are closely linked, that's for sure, and there is a literature on that very extensive. Even if the relationship between economy and human rights is not necessarily always harmonious. On the one hand, human rights are, especially those guaranteed by the Convention, are, and I think, a sine qua non condition for effective economic activity. But on the other hand, we must be mindful of the risk that powerful economic players may pose to right and freedom. And maybe I would like to begin with a few talks on the notion of the crisis itself, because that creates me now more and more problem. The crisis is real, serious, and lasting, as we are frequently, and I am almost tempted to say, hundreds of times per day, in the newspaper, on the radio, on the television. This crisis has infiltrated every debate, and now we cannot have any debate without quoting the crisis. So the crisis has infiltrated every debate and is becoming the prism through which everything is viewed. I mean, of course, the economic crisis, but also the political crisis, the institutional crisis, the crisis of authority, the crisis of democracy. There is a philosopher in France, Myriam Renaud-Davon, and she says, a never-ending crisis, because that's exactly the situation where we are. A never-ending crisis robs us of the future dimension. And this is a strange reversal, given that the modernists, les modernes, have tended, by contrast, to view the crisis as a dynamic period of transition between one era and another. And so, for me, the crisis today is perhaps no longer a crisis, but rather the sign of a transition or shift, a geopolitical, an economic shift undoubtedly, but also a digital shift that we know with our entry into the virtual sixth continent, the web, a biotechnological shift in the new degree of control over the life and procreation, also, of course, an ecological shift with the awareness of the limits imposed of our development models by the finite nature of the world resource. So we are experiencing not only a crisis, but a historical bifurcation. And I borrow this expression to Ilya Prigogine, who is a Belgian, because we have one Nobel Prize in chemistry, not in the humanities, not in law. And he said we have to talk about a historical bifurcation. And this bifurcation holds as many threats as promises. It's not the end of the world, but it's the end of a world. And contemplating its face on leads us not to be pessimistic, but rather determined. So about the crisis itself, I think we have to go far beyond just the immediate meaning of the crisis. So let's now look specifically at economic crisis. Economic crisis, the one we are currently experiencing, and the impact of which on human rights is very well illustrated by many authors and scholars. An impact on human rights, which is diffuse but undeniable, and which pervades everything, even the most remote and unpredictable or unexpected areas. Not only does the economic crisis expose vulnerable people, women, children, migrants, and I think we have to take them into serious consideration, and minorities, but to special hardship, but it also tends to encourage recourse to extremism of different forms and is often accompanied by search of scapegoat. And as history has told us, these threaten and undermine the two pillars on which the Convention is based, democracy and the rule of law. For me, in reality, compliance with human rights standards is not only even more necessary in time of economic crisis, because in increased vulnerability, it also makes a contribution to recovery by establishing the conditions necessary to stability and the proper functioning of the rule of law, both essential to economic growth. So there is no antinomy. For me, they are complementary. In this respect, it seems to me, but you know it's a very difficult matter because now maybe the thing will change and we will see it. In this respect, it seems to me that the European Court of Human Rights has always held that insufficient resources of a state will not normally justify failure to secure convention rights and freedoms, of course, notably when considering Article 3 issues. Thus, for instance, in relation to prison conditions, of course, many examples are coming from criminal law because, as I said, it was my previous background. In relation to prison conditions, the court has taken note of the serious socio-economic problems faced by country, and especially country in transition, and recognized the economic pressure confronting contracting states. It has, however, confirmed that the lack of resource cannot, in principle, justify prison conditions which are so poor as to reach the threshold of treatment contrary to Article 3 of the Convention. And the same principle applies to other provisions of the Convention. So, for instance, the famous Burdoff case concerning Article 6 and concerning the execution of judicial decision. In reality, and I think it's really so the situation, we can see that the court is very reluctant to accept the arguments coming from the government and trying to explain the failure to observe the convention right by the economic crisis or the economic or financial difficulties. And recently, it's a case from last week, 18 June 2013, in the Jashova and Others versus Bulgaria. I'm not sure that I put this case on your plan, don't know, I don't remember. In this case, the court found a violation of Article 2, which is a right to life, in a situation of economic crisis where 15 disabled children and young adults placed in care had died during the winter 1996-1997 for lack of food, heating, or basic care. And the argument was, of course, coming from the economic crisis on that time in Bulgaria. So, I say the situation is changing because on a more general level, and this I don't know if I put the case in your document, we will see. However, on a more general level, the court is now faced with a little bit different situation. The court is faced with the consequences of austerity in some countries and the adoption of stringent budgetary mechanisms. It's a recent inadmissibility decision. When it's an inadmissibility decision, we have no separate opinion. There is no possibility to send the case to the Grand Chamber, which is a pity for me. So it was an inadmissibility decision. The name is Koufaki and Adedi versus Gray. Did I put that on your document? I don't know. Well, in this case, the Greek government adopted a series of austerity measures designed to cut public spending. And such measures of a permanent and retroactive nature and applied without distinction to all public servants include 20% cut in public sector work salaries and pension, and also the curtailment of other financial benefit and allowance such as holiday and bonus months payment. So the applicant contests the compatibility of this draconian measure with the right under Article 1, Protocol 1. In its decision of admissibility, 7 May 2013, the court declared the application inadmissible, having regard to the public interest consideration which underpin the adoption of the measure and the wide margin of appreciation. You know that the margin of appreciation is now becoming a very, very important topic, and Protocol 15 of the Convention, which has been not yet ratified but signed a few weeks ago, put margin of appreciation into the preamble of the Convention. So, quoting the wide margin of appreciation enjoyed by the state in the formulation of economic policy, in particular when it comes to tackling a financial crisis which threatened to overwhelm the country. So there is this decision, but by contrast, there is another judgment 1 week later, what is really special. 1 week later, there is another judgment. We adopt a completely different, not completed, but quite a different position. And in this case, it's a judgment Key NKM versus Hungary, 14 May 2013. So in this respect, concerning on a more general level, the consequence of austerity and cutting budgetary finance, which is the situation in many countries, now the court has already to organize its case on that. We have one case, the Greek one, and we have Hungarian one going, in my humble opinion, in quite another direction. So now let's go a little bit closer to the question of poverty. Against this background, in what extent does the protection which the Convention affords to everyone, Article 1 of the Convention is crystal clear, it's absolutely to everyone, to what extent this protection encompasses the severe hardship caused by economic crisis? Today, the relationship between poverty and human rights is on the political agenda at both international and European law. And you will see in the text there are many, many references of that on the United Nations, on the Council of Europe, on the European Union, on the Fundamental Rights Agency. So that's really the question on the agenda at both international and European level. So I will deal in this context with certain aspects of the contribution made by the court case law in dealing with situations of poverty or extreme poverty. For me, the position is that understanding and applying the intuition, I don't know how to translate intuition into English, the instinct, is it correct? I don't know, but understanding and applying the intuition, the instinct, which underpin the principle of indivisibility of fundamental rights, the European Court soon realized that the effectiveness of political and civil rights is sought to protect, if possible, in certain cases, not only possible if the social implications of those rights were taken on board. Thus, by acknowledging the permeability, the porous nature of the Convention vis-à-vis social rights, the Court has achieved impressive breakthroughs, even if this movement is not without limit and without any critique. Some critique, and you will see that. It's not unreasonable to believe that there could be in the future new development in the case law of the court. Why? Because the court, indeed, is a living instrument to be interpreted in the light of present-day conditions. And I think we are really on a very fundamental point for the European Convention and civil and political rights. Social democracy is not another form of democracy. It is inherent part of any democratic system. As the French sociologue Alain Touraine has said, though in a very interesting book, Qu'est-ce que la démocratie? What is democracy? And I'm sure it has been translated into English. The recognition, and I quote him, the recognition of fundamental rights would be devoid of substance unless it helped to provide security to everyone and continually enlarge the domain of legal guarantees and state intervention to protect the weakest. And he said that is precisely why, at times, talk about human rights become intolerable, if not insulting to someone. And conversely, and that's for me really the dialectic between civil and political rights and social and economic rights, conversely, it may also be argued that the violation of the first generation of fundamental rights, civil and political rights, certainly affects the fragile and random exercise of economic, social, and cultural rights. Take, for instance, Amartya Sen. You know Amartya Sen, who is the recent, not so recent, I think 10 years ago, Nobel Prize for Economics. And he doesn't hesitate to establish a parallel between the non-democratic culture, nature of a political system and famines. And even in argue, and I quote him, in the diverse position, freedom, it is the diverse positive freedom that are available in a democratic state, including the right to hold free election, the exercise of freedom of the press, and of freedom of speech without censorship, that must be seen as the real force behind the elimination of famines. However, let us be clear. Some are opposed, is not strongly hostile, to the social openness of the European Convention of Human Rights. That's for sure, and we have to take that into consideration. But we have to take that into consideration, but maybe also to try to find an answer. And to overcome the opposition between the category of right, some authors have been suggesting, and for long, to look at things from a different perspective, which involves shifting from an individual right point of view to the obligation of the state. Very often you are only looking to the individual rights, but now let's have a look to the obligation of the states. And when we shift the point of view to the obligation of the state, human rights that the state is internationally committed to recognize impose three obligations. And it is the famous tripartite typology of the obligation. To respect human rights, it means, of course, that's very classical, not to interfere with the exercise of right guarantee, to protect human rights, of course, not to accept abuses or infringement, and third, to fulfill human rights. It means to provide the means for an effective exercise of human rights. And there is some consequences from this way of examining the situation. As a consequence, it follows that to affirm that the states and an obligation not only to respect rights and to ensure the protection, but also to ensure the realization. That's in the court and in the convention language is the positive obligation, but also to ensure the realization is to affirm simply that the state cannot remain indifferent to the circumstances of life that separate the guarantee of the individual freedom from his or her effective capacity to enjoy this freedom. And as such, the state is bound to an obligation of progressive realization. And when there is an obligation of progressive realization, where an obligation of such a kind of individual rights is an issue, the decisive criterion, and you can imagine it very easily, the decisive criterion because whether or not states, authorities have made all efforts that could reasonably be expected from them. So this watertight division between civil and political rights can be reconciled in a way through when we change our point of view, not from the individual rights, but the state obligation. The state obligations are threefold: protect, respect, protect, and fulfill. And we can immediately use that in the case law of the court. So, while situations of poverty may result in violation of civil and political rights, persons affected by poverty are also limited in their capacity to assert the right guaranteed by the Convention. But as Emmanuel Decaux wrote many nice pages on that, as he put it, and I quote him, the aim should not be to invent new rights for those living in poverty, but to ensure that the rights proclaimed are genuinely effective for everyone. And that's for me the gist of the problem. To make sure that the right proclaimed for everyone can be effective for everyone. So two consequences from that. First, fighting poverty is not only requires improving income levels, access to housing, of course it's important, but not only that. Food, education, health service, water, sanitation, and so on, but also that person living in poverty have the resources and capabilities to enjoy the whole spectrum of human rights. And in this respect, that's why in a few minutes I will devote a little bit more time to access to justice. In this respect, access to justice plays a crucial role on this, I should say, equation. Second, the content of a right must be the same for all. The content of right must be the same for all. And some use this new concept. I have seen it, but I no further development on it. Some use the concept of integrity in the content of human rights. Maybe you have seen this concept. I haven't, but I saw it recently. Integrity in the content of human rights. And in short, and I think that's the main point, human rights have no meaning unless they apply equally to everyone. And of course, but we have no time for that, it will be interesting to develop the topic of equality. Equality in human rights, of course, has an important role to play. Voilà for the first part. Voilà for the first part, economic and crisis in human rights. Some impressionists talked about that, starting from the meaning of crisis itself, and crisis itself today is a bifurcation, it's a change, and so that's important also in the way we will have to interpret the Convention. I will finish with that. And then all the relation between human rights, the Convention right, and an economic crisis today. The court has a very strong position on that. Okay, economic difficulty do not justify any way to escape obligation, but we can see now on a more general level there is a case law who have to be developed in a situation more macro, more general. Now let's move to the second part. Poverty in the European Court of Human Rights case law. First, access to justice. Access to justice, and then I will tackle, maybe I will see if I have time. The second point will be right to peaceful enjoyment of possession. The third one will be access to justice, yeah. The third one will be toward the right to housing and inhumane and degrading treatment. Voilà, I will see if I have enough time to deal with all these aspects. Access to justice. Access to justice for me is absolutely indispensable and paramount. You know there is a UN special rapporteur on extreme poverty and human rights. And in this report of 2012 and 2013, and you will see all the reference in the footnotes on the text, as the UN Special Rapporteur on Extreme Poverty and Human Rights pointed out, lack of access to justice is a major reason why people fall into and remain in extreme poverty. The lack of access to justice, and therefore effective access to justice, is not only a human right, and it is a human right in itself, Article 6 of the Convention and other instruments as well, but it's also an essential tool to tackle poverty and inequality. Alors, why? Why is it so? Without equal access to justice, without equal access to justice, persons living in poverty are unable to claim their rights, and that's the point, are unable to claim their rights or challenging crimes, abuses of violation committed against them, trapping them in a cycle of impunity, deprivation and exclusion. So that's why access to justice is really the beginning of the situation. And moreover, the relation between poverty and obstructed access to justice is a vicious circle, and that's the problem. It's really becoming now a vicious circle, and we can witness that in many cases at the European Court of Human Rights. The inability of the poor to pursue justice remedies through existing system increase their vulnerability to poverty and violation of their rights, while the increased vulnerability and exclusion further hampers the ability to use the justice system. So we are exactly in this vicious circle. Technically, what are the elements that matter in access to justice? And in this context, even if I cannot have no time to develop that in depth, and maybe I have to read more about that, but in the context of a due process and independence and impartiality of justice, I know that we have the famous 4 A's: availability, accessibility, adequacy, and adaptability. And that's really the way we present the main requirement of access of justice: availability, accessibility, adequacy, adaptability. Alors, concerning availability or accessibility, you know, of course, this famous leading case, Eyre versus Ireland, in October 1979, a very old case, but a leading case, and more you have to come back to the leading cases and even to very old cases, because some of them are really, really extraordinary pearl. So in this Eyre versus Ireland, this judgment affirmed that from the standpoint of Article 6 of the Convention, right to access to court, due process, from the standpoint of Article 6 of the Convention, and in certain circumstances, the state has an obligation, even in civil matters, to provide free legal aid to those most in need. And this principle, this very old principle, was subsequently confirmed and also fine-tuned in many different situations, but also broadened to encompass the entire issue of access to justice. But now, let's be realistic. Of course, we must be realistic. The court never intended to say that there exists an unconditional right of access to justice completely free of charge. So far, the courts haven't said that, no. The court didn't say that there is an unconditional right of access to justice, completely free of charge, and that should be derived from Article 6. Maybe in the future, I don't know, but so far, no. But nevertheless, that provision, interpreted in the light of the Ehret judgment, this provision, Article 6, as on a case-by-case basis, and that's very important, because the development of the case law of the court is a case-by-case, in order to avoid any dogmatism or any problem with sovereignty of state, on a case-by-case basis, on a very modest way, acted as a bar of disproportional financial obstacle, preventing economically vulnerable individuals from gaining access to justice. So we apply that in this kind of situation, disproportionate financial obstacle to access to justice, whether on account of excessive court fees, it could happen, of course, or on account of the refusal to admit ordinary appeals on point of law, to the detriment of persons whose lack of resources made it impossible for them to begin to pay the amount ordered to the judgment in question. And then we have all the case law, in the French case law. And recently, in a more recent case, the court didn't rule out the possibility that a decision ordering the losing party to proceeding to reimburse the winning party legal cost may result in a violation of Article 6. And that's, of course, it's a development. May result in a violation of Article 6 of the Convention if the amount concerned was greatly disproportionate to the final resources of the unsuccessful party. And lastly, that's maybe the most interesting thing, but it's a very tiny and not tiny. In the case Guidi versus Italy, it's a recent case, I think it's still pending because it was an interim measure. The court decided to apply Rule 39 of the Convention. And Rule 39 of the Convention is about interim measure. In order to speed up payment of a sum of 14,000 euros owed by the state concerning the Pinto compensation to the applicant and his daughter, whose situation of severe financial hardship was known to the state. So we use for the first time, and contrary to the case law of the court concerning the use of interim measure, we use it in order to force the state immediately to pay this sum, which is absolutely indispensable for the survival of this family. And we will see another use concerning the house, the problem of the housing. We will see another use of the interim measure, which is also, I'll say, extraordinary, because those who are here in the court who know that we have to use this interim measure only in exceptional circumstances. And now we have two cases where it has been applied. So this issue of access to justice also feature on the European Union agenda, and that's important, especially in this area. And I will quote Martin Schulz, the President of the European Parliament. He said, the crisis is putting existing structure, including our justice system, under increased pressure. While we act all in a prolonged global economic slowdown that force government to stringent budgetary cuts, those values guaranteed in the Lisbon Treaty should in no way be undermined. And that's a very important statement. And of course, you know, those values enshrined in the Lisbon Treaty are respect for human dignity, freedom, democracy, security, and the respect of human rights, Article 2 of the treaty. So that's really a political statement. And look also at the topic of the Fundamental Rights Conference organized in 2012 by the Fundamental Rights Agency. The title is very significant: Justice in Austerity, Challenge and Opportunities for Access to Justice. And in Mr. Kerum's view, and Kerum is the director of the Fundamental Rights Agency, in his view, the conclusion is clear. Access to justice should be strengthened in time of crisis, doit être renforcé en temps de crise. Cutting budget during such time simply shows a lack of long-term vision. And that's for me the crucial point. It's a lack of long-term vision. In the time of crisis, if we think crisis is a change of paradigm with a shift, we must have a long-term vision and absolutely not a short-term vision. And so it's maybe more practically, we have to encourage for access to justice innovative solutions capable of contributing to the shifting of future politics. But ultimately, because we have also to go and to see further, ultimately, as Olivier de Scutter, for instance, explains, ensuring meaningful access to justice for persons living in poverty does not depend only on legal tools of access of legal services. Of course, that's the first step, and we have to take that into consideration. Of course, the legal services are important, lawyers, court, but also requires a more holistic approach. A more holistic approach that takes into account broader structural, social, and economic factors. Because the causes of the limited access are in the lack of expression, education, access to decision-making, and also political disempowerment as a result of lack of accountability. So to improve access to justice and reduce poverty, states must tackle all the obstacles in a holistic manner, creating the condition to enable those who are socially or economically disadvantaged to enjoy a real opportunity. And that's, of course, one of the main important points. So for the right to access to court, I devote a little bit more time to that because I think it's really not only important to reduce poverty, but also so important for the role and the task and the possibility of the European Court of Human Rights. Second point, but I chose this point, maybe there are others, right to the peaceful enjoyment of possession. Alors that we are really in the situation of a paradox, because paradoxically, the court constructive interpretation of Article 1 of the first additional protocol has resulted in some remarkable advance being made in the field of social protection. It is a little bit paradoxically, that is the Article 1, Protocol 1 is really the right for the property and possession that is made possible to advance in the field of social protection. Leading decision, you know, Steck versus UK. And those who are reluctant, those who are critical about the development of the court into the social field are, of course, criticizing very heavily this decision, that for sure. The leading case for me is Steck versus UK. And this Steck versus UK is summarized and explained upon the existing law, and you will see that we explain that in other case law, accepting that the notion of possession contained in that provision, in that convention provision, could extend to all social security benefits, whether contributory or not contributory. And significantly, the court observed that in modern democratic state, and I quote, many individuals are, for all or part of their lives, completely dependent for survival on social security and welfare benefits. Where an individual has an assertable right under domestic law for a welfare benefit, the importance of that interest should also be reflected by holding Article 1, Protocol 1 applicable. That's why STEC is so important, because it recognizes the situation of people now, today, living or depending on survival of social security. But de nouveau, we must be realistic. Of course, this does not mean that states party to the convention are henceforth requested to guarantee social security benefits that do not exist under the legal system. Of course, it's not the task of the convention to force states to create social benefit. However, and that's an indirect way, however, Article 1, Protocol 1, read in conjunction with Article 14 of the Convention, and very often we use that. One article read in conjunction with another article of the Convention precludes refusing such benefits where they exist on ground of sex, marital status, nationality. Of course, if this right exists, we cannot refuse it on a ground of sex, marital status, nationality. And the combination of Article 1 and Article 14 is all the more effective since, in a parallel development, the recent case law of the court has produced an interpretation of Article 14 particularly favorable to the protection of groups that are structurally vulnerable, as women, children, minorities, by accepting the legitimacy of positive action. So by conjunction of these two provisions, there is a possibility of development. And so, when the court, for instance, in a case against Czech Republic, asserting the prohibition of indirect discrimination, of ruling that the burden of proof regarding discrimination must be shared, with the combination of the two dispositions, there is, of course, a possibility of enhancing the protection of Article 1, Protocol 1 concerning social protection. Right to, yes, I forgot that, sorry. Right to private and family life and respect for the home. That's a very classical situation, of course. Article 8 of the Convention, we know that right to private life, right to family life, right to protection of home. Right to private life, we have many, many cases on this, and maybe I will not go in depth in that because that's more classical and I think much more known by you. Moldova against Romania, that's a perfect example. 2002, the court examined from the standpoint of Article 8 and the right to respect for private life, because this aspect was in what at stake in this case, the extremely precarious situation of a person whose house has been burned down, and found a violation of the provision of Article 8, private life. Family life, of course, we have the famous Walola and Wala versus Czech Republic judgment 2006. That should be a leading case as far as the facts are concerned, because the children have been placed in a family, not because the parents were unable to educate them, not at all, because it was crystal clear from the judgment, and not from the judgment, I mean the judgment of the internal domestic authorities, that the parents have all the quality to educate children, but the only reason to place them in this not family but institution was because it was an impossibility to have appropriate housing. So it was a question of poverty, and it was crystal clear from the elements of the discussion of the domestic authorities that it was not the personal situation of the parent, it was only the question of poverty that justified the placement. And then the court say to comply with the requirement of proportionality in this case, because the proportionality in Article 8, 9, 10 are, of course, the gist of the examination. To comply with the requirement of proportionality in this case, the authority should have had recourse to less drastic measure. That's proportionality. If you can have a less drastic measure concerning human rights, you have to use it on priority. Less drastic measure than to taking care of the children. And indeed, the role of the social welfare authority is precisely to help people in difficulties who lack knowledge of the system. And that's referring what we have said before. Respect for home, we have, of course, the McCann versus UK judgment 2008, in which the court states on the subject of the applicant eviction from a local authority dwelling, owner dwelling, that the loss of home is a most extreme form of interference with the right to respect for home. And the result for any such measure was permissible only if it's possible to have its proportionality effectively reviewed by the court. So in this case, the court didn't say nothing about the right to home, but it said if there is an interference in this right, it's absolutely indispensable to have the proportionality reviewed by a court. Toward the right to housing, maybe I will say a few words on that, but not too long because time is flying. Towards a right of housing, question mark. Question mark because it's not so sure, but I think maybe we are on the way to that. The issue of the position occupied by the right of housing in the law of the European Convention of Human Rights is worth raising. On the one hand, it is true as matter stands now that the convention doesn't protect a right to housing as such, as we say. No, there is no right to housing as such, although the possibility of the change in that situation cannot be discounted should the court be called upon to examine cases that may permit to extend or fine-tune its case law. So, no right under the convention. Okay, but on the other hand, it would be just as much as overstatement to say that because it has not attained that status housing of law, housing is simply consigned to a legal limbo, where the Convention is concerned, beyond the reach of the European human rights judges. There is a space, I think there is a space, an important space, between the full-blown personal right and pure facts. Between right and facts, what do we have? And many legal theorists explain that to us. Between right and facts, we have the notion of interest, legally protected interest. And for me, it seems indisputable, in the light of the case law of the European Court, that housing already enjoys that status. Not yet a full right, not only a pure fact. In the space between right and facts, there is a legal interest. Legal interest, and we can see that in many case law, and the recognition of the right of using of an interest protected by the Convention emerged very clearly also of a very old case. Very old case is James versus UK, James and other versus UK, 1986, because in this case we can examine the limits that may impose on property rights. And through the limits imposed on property rights, we can see that the right of housing becoming more and more a legal interest protected. And I will just quote one phrase of this very, very well-known case, but still tout à fait actuel. And I quote, "Eliminating what are judged to be social injustice is an example of function of a democratic legislature. More especially, modern society consider housing of the population to be a prime social need, the regulation of which cannot entirely be left to the play of market forces." And we have seen that in other cases of the court, and I will just quote, for instance, the Utemczaska. Utemczaska versus Poland, it's a pilot judgment, and a pilot judgment is very important because, of course, it paved the way for general measure. In Utemczaska, Poland, 2006, which concern rent control in the context of a housing crisis situation, the court say, as regards the general measure to be applied by the Polish state in order to put an end to the systemic violation of the right of property identified in the case, and having regard, and that's important, to the social and economic dimension, including the state duties in relation to the social rights of other persons, the court considered that the respondent state must, above all, through appropriate legal activity, other measure, secure in its domestic legal order. On the one hand, a mechanism maintaining a fine balance, a fair balance, for the interests of landlords, including, on the other hand, the entitlement to derive profit from their property, and the general interest of the community, including the availability of sufficient accommodation for the less well-off. So in this Utemczaska pilot judgment, the court have said very clearly that we must find a balance between, of course, the legitimate interest of the owner and also the general interest of the community, including the availability of sufficient accommodation for the less well-off. That's exactly the legally protected interest. And more recently, in a judgment Almeida Foreda against Portugal in 2010, the court found that the statutory bar for terminating a long-term lease did not infringe the applicant's property rights because, in this specific case, the legislation was based on concern to protect a section of society deemed by the state to require special protection. And in a different context, the court declared inadmissible a complaint based on Article 1, Protocol 1, and also Article 6, alleging that the public authorities has refused to enforce a final court ruling ordering the clearing of a block of flats on the grounds inter alia that the squatters were in a precarious and vulnerable situation and therefore observed enhanced protection. So from these two recent cases, only that, Utemczaska pilot, these two cases, Portugal, and what's the name of the other case? I don't remember them. Yes, it's a French case. It's a French case, Cofino Society, Cofino versus France. And lastly, as I said concerning the Guidi case, in the case AMB and other versus Spain, which are brought before the court on December last year, 2012, and is currently pending before the court, the president of the third section decide to indicate to the government not to carry out the applicant and the other children eviction from home they occupy. So under the umbrella of Article 39 interim measure, it was not 6 months ago, not even 6 months ago, also contrary to the current case law, the president of the third section decided to apply Article 39, to apply interim measure, because, and to force, to indicate to the government not to carry out the eviction of the flat people occupy. So when we are studying all these examples, I think it's quite clear for me that now we are really on the way to find between right and fact legal protective interest. Now, last point in human and degrading treatment. From the point of view, and maybe I would start with that, but why do I say that at the end? I don't know. Because, of course, Article 3 is the most important provision, one of the most important provisions of the Convention. But from the point of view of Article 3 of the Convention, we can and we should raise the question as to the applicability of this provision, Article 3, as a basis for a state duties toward person in difficulty. I know it's going maybe a little bit far, I know, but if we don't try to think about solutions that could be really prospective, we will never do anything. It would be, unthinkable not to consider that extreme poverty, and I quote the usual case law of the court when we are using Article 3 of the Convention, it's difficult not to consider that extreme poverty, and I quote the case law of the court in other cases, humiliates the individual in his own eyes and in the eyes of the others, and is such as to arouse feelings of fear, anguish, and inferiority. Pierre-Henri Habert, who has been for a long time Director of Human Rights in the Council of Europe, he put it, and I saw it's a little bit provocative. Is it not really ridiculous to think that if corporal punishment in school is referring to the Tyre case in 1976 or 1979, to think that if corporal punishment in school is considered to be degrading, the same should apply to the situation of someone who lives in a slum. So now the question is open. The question is open concerning the obligation of the state. Have in mind the triple obligation of state to respect, to protect, to fulfill. We have to that in mind. I have to confess, and that's normal, that today the absolute nature of the Article 3, because you know that Article 3 is an absolute right. Absolute right, and it means that the situation coming within the ambit of that provision are not normally justified on any grounds, including budgetary grounds. The fact that Article 3 is absolutely right calls all matter as a matter of necessity for a certain degree of restraint in applying it. And then we can see that, in other words, the court is a bit reluctant or afraid to use it too much and to say that it reaches a threshold of human suffering, the famous threshold of Article 3, because, of course, since it's an absolute right, we cannot have any other justification. So the best is the enemy of the good. The fact that it is an absolute right could delay its application. And we have some decision of the former Commission and of the Court where no, the Article 3 was not applied, and I'm just quoting the Aurore versus Aurore, I cannot pronounce that, versus UK, and you have the case in your document, and also the former Commission decision in the Van Volsem versus Belgium, which has been heavily criticized, and it's impossible now that we still have such a case. It's impossible. The situation has completely changed, so we cannot imagine today have this kind of case. So, okay, we have this case law, we have the Aurore case versus UK, where the court didn't find that the situation of these people living prisoner and was living in street reach the threshold of Article 3, but we have also other cases. And that's why we have divergent position. We have also other cases, and this line, I should say, I cannot say that this previous line of case law has been superseded, but it has been slightly modified, for instance, for a case against Russia, Larioshina versus Russia decision of April 2002, which states as follows, and I quote, the court recalls that in principle, it cannot substitute itself for the national authorities in assessing or reviewing the level of financial benefits available under a social assistance scheme. This being said, that's exactly the obiter dictum. I love obiter dictum, this small sentence that you can find in a case and we can change the face of the world in other cases. This being said, the court considered that a complaint about a wholly insufficient amount of pension and the other social benefit may, in principle, raise an issue under Article 3 of the Convention which prohibits inhuman and degrading treatment. May, in principle, in other case, raise an issue. And that's exactly the way where we can find, where maybe we can use this obiter dictum of the Larioshina case in other situations where the situation is more clear, is more obvious, and can be used. So that's really a sentence which paved the way for evolvement or development of the case law. And in Budina case, it's a case in 2009, so more recent, the court pursued the same line and addressed the argument which, in their view of some observers, weighed in favor of a change in the case law. Because some scholars, for instance, Diane Roman in France, asked for a change in the case law. The court didn't rule out that the possibility that the state responsibility could be engaged on account of the treatment meted out to the applicant, who was totally dependent of the state support and found herself faced with official indifference despite living in a state of great hardship incompatible with human dignity. So when you put these two cases one after another, Larioshina and then Bourdina, with obiter dictum in the first one, and non-applicability the second one because it was not an appropriate case, we can see there is something in that. And lastly, another consequences of the economic crisis which the court has dealt with in the context of Article 3, because in Article 3 we have all these cases, but there is another aspect concerning the context of Article 3, is the increasing influx of migrants and asylum seekers. Though that's a completely different situation. Look at the MSS versus Belgium and Greece case. Judgment 21 January 2011. In which an asylum seeker, because of the authorities' inaction, had found himself living in Greece on the street for several months, with no resource or access to sanitary facilities, and without any means of providing for the essential needs, the court found that the applicant has been the victim of humiliating treatment, showing a lack of respect of his dignity, and that the situation has aroused in him feeling, fear, anguish, or inferiority capable of inducing desperation. And the court considered in this famous MSS versus Belgium Greece case, the court considered that such living condition, combined with the prolonged uncertainty in which he had remained and that the total lack of prospect of this situation improving, had attained the level of severity required to fall within the scope of Article 3. So we can see that this Article 3, some say it's impossible, it's completely unrealistic and completely utopic to think that Article 3 can play a role in this situation. With due respect, I am not sure. I am not sure, and I think with different aspects we realize that there is something in this argument. And in the last case, Hirshijama and others versus Italy, 2012, the court observed, and that's important because coming from the individual aspect to the more general aspect, the court observed that the economic crisis and recent social and political change have had a particular impact on certain regions of Africa and Middle East, throwing up new challenges to European states in terms of immigration control. And in that case, Hirsi Jama and others, the court didn't hesitate to assert that, and I quote, having regard to the absolute character of the right secured by Article 3, that situation cannot absolve the state of the obligation under that protection. So we can see that here the absolute nature, on the contrary, help to reinforce the obligation. Conclusion. This last judgment, I mean Hirsi Jama and MSS, this last judgment takes me back to my starting point. If we accept that crisis and economic crisis are not just cyclical, but are the sign of a new shift, on a bifurcation, I believe that as far as human rights and European Convention on Human Rights are concerned, This should prompt us to lend greater meaning, scope, and effect to the indivisibility on fundamental human rights. Because indivisibility of fundamental human rights is without doubt the guiding lines or the l'horizon régulateur, the guiding lines for the international protection of human rights. Our former president, Brazza, he was well, all the presidents are good, but he was good, of course. The President Brazza reminded us in January 2012, so last year, in his opening speech on the judicial year on the European Court of Human Rights. And he said this: in time of crisis, the protection of human rights is not a luxury. It's not a luxury, but is more than ever a necessity. And conversely, if we don't think so, the paradox of our democracy today would be to make poverty the place of inequality in fundamental human rights. And a last word, just a last word of conclusion. I would like to refer to a notion that has been criticized by many, and I know that. And maybe I share this criticism. It is the famous notion of dignity. I know it's a critical notion, but I think in this field maybe we can use it in a very important way. I suppose that you know the work of Hannah Arendt, this famous philosopher who, as far as right is concerned, I think for me it's really so important to read and to read it again, and especially the book Les Origines du Totalitarisme. And in this book, Hannah Arendt's criticism of reference to human dignity is based on experience of the Holocaust. And she says that the invoking of dignity risks being tragically useless if certain conditions are not fulfilled. And that's for me the important point. A person cannot have rights and cannot therefore see his or her dignity respected unless he or she is part of a public and legal community. If human rights were not able to prevent extermination camps, it is because the human beings who perished there no longer had any legal status. Human rights and dignity cannot content themselves with concerning an abstract man, but must necessarily refer to the person included in a political community. So it is absolutely essential to recognize men and women, all equal beings, of course, the quality of subject of dignity, the poor, the foreigners. We could have said the same lecture about foreigners, the poor, foreigners, all this excluded. That's the reason why those who have accepted the daunting function of judging, and I think I did that for 14 years, must restore vulnerable people quality of subject of dignity, to be involved, to be in a local political community. That's why the critical concept of dignity has any sense if we decide that we have to give this subject of dignity to all of us. Voila, that's what I would like to say to you concerning this topic. I know it's not a topic which is related to your to the main topic or the main theme of your course here, but voila, that's a topic I would like to say a few words, because for me, after so many years at the court, I think it's maybe the most important one. The most important one, and that's why the court is for, to try to deal with this situation. Okay, now we have time for discussion, and I am, of course, ready to your disposal to answer to my humble possibilities to all your questions. Thank you very much for your kind attention.